Death is an unfortunate part of reality, but I'm sure when that day comes, you want to be fully prepared. You don't want friends and family picking up the pieces of your lives while they're sitting there grieving. If you don't want to leave your family within a mess, then an estate plan is an essential part of retirement planning. The unfortunate truth is that many people haphazardly plan for the finish line of their life. And I often see people make mistakes that are easily avoidable that cause their families a lot of pain and frustration. And it's mainly just because they don't know the rules when it comes to estate planning. And in doing so, they subject their loved ones to years of probate court, years of time, and tons of expenses that come along the way. So in this video, we're going to talk about 13 mistakes that people commonly make when it comes to their estate planning so that you can avoid them when creating your own estate plan and planning for your finish line of life. I'm Josh Bennett with Mr. Money Sense TV, the channel where we help you earn more, keep more, and grow more money. If you're new here, please subscribe so that way you don't miss any future videos. We provide a lot of videos and tips and tricks on how to grow your wealth. So let's dig into the 13 mistakes that many people make when it comes to their estate plan. Mistake number 1 is assuming that your will take care of all the details. That is not the case. So if you have like an IRA or a 401k through a company, if you have a beneficiary on that 401k that does not match what's in your will, that beneficiary will trump what's in your will. So if all your beneficiaries and your will aren't aligned, your money can end up going to someone that you did not anticipate it going to. And that obviously is not fun for anybody. Another mistake is giving your heirs an avoidable tax bill. So if you have like an IRA or 401k or another qualified account, what you can do is you can actually, if you designate them as a beneficiary, they can get what's called an inherited IRA, and they can stretch out that income over the course of their life, which can really spread out that tax bill. Whereas if you don't have a beneficiary on the account, it goes to probate, and then once it goes through probate, it goes to the heirs, and they could be forced to take that money out within 5 years, which means they're going to take that tax hit immediately, and it may be a much bigger tax hit than they anticipated and are necessarily ready for. So by not planning, you're giving your loved ones a potentially unforeseen tax bill that could be avoided. Another mistake is triggering probate court on your life insurance proceeds. So if you don't have an individual named as a beneficiary in your life insurance, well then that can trigger your life insurance to go to probate. And then again, once it goes to probate, so probate court is just the court system that designates where your money goes when you pass away if you don't have a will or trust in place. And by not having a beneficiary on that life insurance, it's going to trigger your money to go through that probate court system, which can take time, money, and expenses for your loved ones. So you want to make sure you have a beneficiary named on your life insurance. Another mistake is forgetting to update your estate plan when life happens. So this is almost as bad as not having a beneficiary in the first place as having the wrong beneficiary. So say you get a divorce or something similar happens, well, you may want to change your beneficiaries because you may not want your ex getting your money. Well, if you don't go and proactively change those beneficiaries, that may very well happen. And that's a mistake that I see, frankly, all the time. And it makes people very upset when their money goes to ex-family members instead of the family members that they wanted it to go to. Another mistake is not having a plan B. So a lot of people will put a primary beneficiary on their accounts, but then not name a contingent beneficiary. So what can happen is if, say, obviously hopefully this doesn't happen, but say your primary beneficiary passes away before you do. That means that you then all of a sudden have no beneficiary. So you don't have a plan B, that money goes to probate. A common but morbid example is, say you have a husband and wife, husband's beneficiary, wife's beneficiary, etc. But say both husband and wife are in a car together, both die simultaneously in a car wreck, well then there may be no predetermined way that money goes, where that might not have been their wishes. They were planning for a best case scenario where one spouse dies naturally, then the other spouse just outlives and then dies naturally later on. Well, you can't necessarily plan for just the best case scenarios. You plan for the worst, hope for the best. And that's what you need to do in terms of having a plan B with your beneficiaries. Another mistake is designating minors as beneficiaries. So in most states, minors are only allowed to inherit a certain amount of money. So you need to basically designate a guardian as the beneficiary while that person is a minor. So you have someone basically monitoring that money and taking care of that minor until they reach an age where they can then get their inheritance. So make sure you name, if you have a minor that you want to designate as a beneficiary, make sure you're adding some sort of guardian to that estate plan so that way they're getting this all passed. Another mistake I commonly see is accidentally disinheriting kids from a previous marriage. So let's look through an example. So say you divorced, you have kids from a previous marriage, and now with your new spouse, you have money in joint accounts. Well, how that works is if you were to pass away, that money automatically goes from you to your spouse. So it just automatically transfers. Well, what can happen is that leaves your kids from the previous marriage no means to contest the transfer of that money. So if you don't have an estate plan and you just have joint accounts or beneficiary set up like that, if that money is getting automatically transferred to your new spouse, they could inadvertently disinherit your kids from the previous marriage. So make sure you have that, your exact wishes again, laid out how you want them done, and make sure the accounts that you're using work with how you want your assets laid out. Another mistake is accidentally overlooking people that you want to take care of. So in estate planning and in estate law, what happens is estate law favors spouses. So it's kind of geared towards where like all the money goes towards your spouse. Well, say you have life partner or charity or something like that you want to give money to. Well, if you don't have that laid out specifically, it's going to go in favor of your spouse, and that's where your money's going to end up going. So if you have specific people that you want to take care of in your life, or charities or organizations that you want to take care of in your life, you need to spell that out ahead of time. Another mistake is failing to get written permission for your qualified retirement plans to go to somebody other than your spouse. So again, estate law really favors your spouse. So there's someone that you want it to go to, like say your 401k, to go to other than your spouse, whether that's charity, organization, partner, whatever the case may be, then you have to get written permission from your spouse for that qualified retirement money to go somewhere other than to your spouse. So again, if you want that to happen, it has to be done and designated well ahead of time. Another mistake I see all the time is assuming that your wishes are on file. So if you added beneficiaries to an account that's 30 years old or something like that, like don't assume that your beneficiaries are on file. And another instance is like say you currently have your accounts at Charles Schwab, move them to TD Ameritrade. Don't assume that your beneficiaries are going to travel with that account. You need to redesignate, and honestly, I would review your beneficiaries almost yearly, if not even more frequent than that, just to make sure that all of your accounts have your wishes on file as you want them to be done. So that way, again, never assume that your wishes are on file, confirm that they're on file. Another mistake is updating forms incorrectly. So if you have an old beneficiary form, for example, and you go in and just initial with an update, that may not hold up in court. So what does hold up in court is a new, fresh beneficiary form, not just an amended old existing one. You want to make sure you redo your beneficiaries entirely if you have any sort of update to your beneficiary, because just an initial and an update on an old form may not hold up in court. So again, make sure you are redoing your beneficiaries from scratch. Another mistake that I see all the time, and this can really be detrimental for families and their emotional state, and that's keeping your estate plans a secret. And I know that there's like kind of this innate need for privacy or want for privacy when it comes to your end of life wishes, because you don't want to hurt people's feelings and you don't want to have some of those tougher conversations. But what can happen is if you don't lay out these things in an estate plan or tell your loved ones where to find documents, where to find your accounts, well, what ends up happening is they're going to have to call all the banks, all the brokerage firms, just to find out where your money is and what to do with it. So you really want your loved ones to know exactly where your money is, know exactly what to do when that time comes, and have that all laid out. And then also what happens is you can have some of those tough conversations while you're alive and while you're thinking through this process. If there's issues, say, you want to give one child a little less than another child because they maybe are contributing more to the family just via time instead of resources, or something of that nature, where you can have some of these tough conversations while it's alive, and while you're alive, and that can help prevent is things like contested wills, where people are going to court over what your will says and trying to fight each other. And I see a lot of in-family fighting, and that's mainly due to just lack of communication and not being upfront with what your wishes were and why, and having some of those tough conversations while you're alive. So don't keep your estate plans a secret. Bring your family and have it be a family conversation. Make sure your wishes are very clear and that you can talk through any of those issues up front. And one final mistake I see, and this sounds kind of funny, but it can happen, and it's a big issue, and that's just misspelling names. And as bad as it may seem, you don't want your money going to someone that you didn't intend it to because of a typo. So make sure you're spelling names correctly on your documents, and that social security numbers and birthdays and things like that to identify the person that you want it to go to. Make sure those are accurate on the files that you are where you're designating these beneficiaries or putting them in your trust, etc. Make sure everything's accurate. Don't have any typos, misspellings, or things left out. Make sure the information is accurate. I hope you found this information useful. If you do, again, please consider subscribing. If you have any questions when it comes to estate planning, I urge you to meet with an estate planning attorney. They can really dig deep into the legalities of your estate and really see what your holes in your plans are, and they can review trust documents, all those sort of things. So I really recommend meeting with a trust attorney. But also, if you have any questions, just when it comes to planning around end of life questions and things like that, leave a question in the comments. I'm always happy to help any way that I can. I hope you found this valuable again, and cheers.